This is Chapter 14, Part 1. Okay, so now we're dealing with sales and lease contracts, and this brings us up to the Uniform Commercial Code. The Uniform Commercial Code is the uniform law that was written so that all the states in the United States would adopt it, and we would have uniform laws for one area of contracts across the country. This would make it easier because we wouldn't have any conflicts between a law of one state and a law of another state. So it's the most comprehensive codification of the broad spectrum of laws involved in commercial transactions. And one of the goals of the UCC is to streamline commercial transactions. Okay, so Article 2 of the UCC deals with the sale of goods. Article 1 deals with definitions and other explanations of the UCC. So if you have a question about a definition that does not appear in the particular article, go back to Article 1. There are several other articles in the UCC, such as negotiable instruments. We're not talking about those today. We're talking about 2 and 2A. Article 2A deals with leases. So Article 2 deals with the sale of goods and sets requirements for sales contracts as well as duties and obligations for the parties involved in a sales contract. 2A, as I said, deals with leases. So one of the principles of the UCC is that it allows the parties to freely contract with regard to any terms that they like, and the UCC only steps in when they don't enter into such agreement. So the second rule is that whenever there's a conflict between common law and the UCC applies. Article 2 deals with the sale of goods. It doesn't deal with real property as real estate, and it doesn't deal with services or intangible property. These are covered by the common law. What's a sale? A sale is the passing of title from one seller to a buyer for a price. It can be payable in cash, goods, or services. What are goods? It's an item of property that is tangible and movable. Tangible property is things like a car, things that can be touched or seen. Intangible property is things like patents and copyrights and stocks and bonds, things that only has a conceptual existence. So what happens when you have a transaction that involves both the sale of a good and a service? So in those situations, the courts have ruled that the predominant action with regard to the transaction is going to define whether it's a sale or a service. That is, which is the primary aspect of it. For example, if you go to Goodyear to buy a tire for your car, and you buy a tire and have it installed on your car, that is a transaction that involves both a good, the tire, and a service, the installation. But the courts are likely to rule that the predominant factor there is a good, the tire itself. And in that situation, the UCC would be applicable. Who's a merchant? Article 2 imposes special standards on a merchant who has special business expertise and is not a casual buyer or seller. So a merchant is a person who deals in goods of the kind in the sale, holds himself or herself out as having special expertise, knowledge, or skill, and employs a person who employs a merchant as a broker, agent, or other intermediary is also a merchant. Okay. As I said, 2A deals with leases. A lease is a transfer of the right to possess and use goods for a period of time in exchange for payment. So you have the lessor and the lessee. The person who is leasing out the property is the lessor. The person who's receiving the property is the lessee. So the UCC states that a sales or lease contract with open terms will not fail for indefiniteness. Notice the difference between this and the rule of law under common law, where the terms had to be definite. So this is the modernization of commercial transactions, making it easier for the court to find a contract and less likely that the parties will take a dispute to court. So here, if the parties intended to make a contract and there's open terms, then the court is likely to find a contract. If there's a reasonably certain basis for the court to grant an appropriate remedy, again, the court's going to find a contract. In some situations, the UCC actually provides some provisions that can be used to fill the gaps when there is an open term in the contract. However, if there's too many open terms, courts will probably find that the parties didn't intend to make a contract and therefore find that there was no contract. The quantity of goods is generally an exception in that it cannot usually be open-ended, except for certain exceptions that we won't go into right now. The UCC has a statute of frauds. That means that certain contracts have to be in writing. One of those is any contracts for goods priced at over $500. For leases, it's $1,000. Otherwise, it's not enforceable. A writing can include any email or other electronic record, as long as it indicates that the parties intended to enter into a contract, and there is some sort of signature against whom the enforcement is sought. And we talked about in e-contracts how that can be a check the box or other types of substituted signature. Usually it won't be enforceable beyond the amount of goods shown in the writing. And for leases, it has to reasonably identify and describe the goods leased and the lease term. Some exceptions to the writing requirement: specially manufactured goods. Oral contracts for specially manufactured goods will be enforced. Admissions, where there is an admission by a party who's breaching the contract, then that will be enforced. In situations of partial performance, if payment has been made or the goods have been accepted, the courts may enforce the contract even though it is not in writing and would otherwise violate the statute of frauds. The UCC has an unconscionability provision. A court can evaluate a contract or any clause in the contract, and if it deems it unconscionable at the time it was made, the court can take certain actions. Those actions are refuse to enforce the contract, enforce the remainder of the contract without the unconscionable part, or limit application of the unconscionable term to avoid an unconscionable result. Okay, so that ends part 1 of chapter 14. The magic word for chapter 14 is sales.